All right. So apparently we had an intermission. That might happen a lot since everybody's working from home now. Is the home anyways, but you're going to find that internet connections are going to suffer. There's a lot of problems because they're not home connections are not built the same as big office connections. The pipelines are different and they're just not meant to handle this kind of constant traffic. So we're going to probably find that we're going to have a lot of disruption, a lot of slower internet connections. So just bear with me on these. If they get real bad, I'll just make pre-recorded videos of this material. Okay. So where were we? We were on the third stage, or the third subsection, which is post-trial motions, and we were talking about getting your order entered, your final order. So there's going to be it can be a whole nother trial. It can cost a whole nother $30,000 to get that in. And I think we decided that this gal, it's dollars an hour, could end up costing you, let's just say $35,000. Okay. I know my handwriting is terrible on these. So we'll just say $35,000 total here. You had a $5,000 to $10,000 retainer here. Oh, you had to renew this retainer because remember we're talking about average cost of a high conflict custody battle is $70,000. Does not include this stage typically. I don't believe that they calculated in if you had to have a whole nother trial battle over those orders, because I know darn well that's going to go over 70,000 if you have an attorney that's $350, $400 an hour, even at 300 an hour. So your pretrial motions haven't even come into play yet because you've got to get that final order in. And so that's opportunity to try to get the court to correct something in that final order, but it's not opportunity to argue something new. So when you're looking at your case and deciding if what post-trial motions you need to file, we've handled that in our motions package. We have arguments in there that you would put into post-trial motions. Okay, so you've got that. Okay, arguments for pre-trial and pre-trial motion. Then we've got arguments to put into your petition or your counter petitions. So that handles it for the trial. And then we have arguments pre-made for your post-trial motions. Now, the arguments regarding your order, that we don't have anything on that because that's specific to the issues that you had. So let's say the judge said you get to choose where to put your child in school and you get decision making on the activities, but not on the actual education. And when the order comes out, it says the other parent gets exclusive decision making. If it did get entered in properly, sorry if I'm repeating, but my camera is saying that my video said that it was reconnecting. If it got entered in properly, then you could talk to an attorney about doing a nunc-pro-tunc. I'm gonna write that on here so you know how to spell it. And just because I'm not an attorney, I can't teach you about these legal terms because you are allowed to give legal education. I'm just not allowed to represent. I'm not allowed to say I'm a lawyer because I'm not, and I'm not allowed to represent any of you. Okay. So you do need to check with an attorney, see if there's a different solution for you or a different way that your state does it. But most states I know, they do nunc-pro-tunc, which is just to correct the order itself. Okay, so once you've got that order in, then you're going to look at and see what you might have that would qualify as for post-trial motion. So what would qualify? If you didn't feel that your parental rights arguments were made clearly enough, right? They were raised, but you didn't feel that they were really articulated as clearly and thoroughly as you wanted them to. Even if you did a pre-trial brief, okay, a trial brief, that's fine. There could still be some things that you needed to clarify and didn't realize it until after the hearing was held. You felt that maybe the judge didn't understand it. That's why they ruled the way they did. You would put that in there. The other reason is because you need to make sure and make clear that it's preserved for appeal, right? And then the third reasons that I've come across is you need to object to something. Maybe the judge made his order and wrote his opinion after that. You would do that in post-trial motions if you disagreed with his reasoning. Because again, what are we trying to do here? What's the goal? Establishing clear rules of law regarding your parental rights. Okay. So now you're in the post-trial part, and we just went over that. Let's see if I missed anything from my notes. Oh, the other reason you're doing the post-trial motions is because you might get it solved without having to go to appeal. Sure, it's going to be nice when somebody gets to take this all the way up, and several parents have, and they've been denied Supreme Court level, and we need more of those. But we want you to be able to get it solved, period. So the mission's second, the social justice reform is second. Your results, your outcome, getting justice for yourself is first. So don't put this movement before you being able to resolve. I've seen parents do that, like not come to an agreement on something because they get so stuck on their argument, and they want to progress that argument. Don't do that to your child or yourself. Okay. If you can get this resolved in post-trial, do it. The other thing you want to think about is while you're arguing this post-trial, you might want to ask for the judge to put a stay on the order so that if there's something that's going to go into place that's going to happen that maybe you can't recover from, maybe you have to pay a bunch of money, and you probably won't get it back. They don't garnish to get that back for you if the judge changes their mind on the monetary part of the order. So you might want to ask for a stay if there's things that are going to go into place before you can get this argued fully and get rulings on that argument. Okay. See if anything else in the post-trial part. Let's see. Oh, and also when you make those arguments, I can't believe I almost forgot about this one. It makes it easier for you to refer to it on appeal, and you don't have to put as much, you don't have to write out as much on appeal. You have limited words on appeal, so you won't have enough room to articulate everything thoroughly, but you can refer to those documents in the record. You can refer to sections in the record. So it gives you a lot more that you're able to argue on appeal. That is huge. Okay. We always run out of room. Helping attorneys and pro se's always run out of room for their arguments because they violate so many of your procedural rights and your substantive rights. And let's talk about that for a minute. What's a substantive right? Like if your substantive due process is violated, what would be a good example of that? Cutting off access to your child without proving you unfit. Okay, that would be an example of a substantive due process violation. Okay, we already talked about some of the First Amendment violations, so I'm not going to go over that again, but what would be an example of a procedural due process violation? We brought that up earlier, so if you remember that, put it down in the bottom in the comments, and I will comment on that later to tell you, because I'm not going to tell you what that one is right this second either. Noting it down so I don't forget. Okay. So next section. So you've got this. So now we've, I don't know if you've agreed, but we'll just say that you agreed that it's going to cost you probably more than that up there. And how many of you could afford to go out and buy a car that costs $70,000? All of this can take place in 1 year. Yeah, sure. Some of these go on for years and years, but I'm telling you, all of this can take place. There's things we've left out of this section. We didn't put in, I mentioned it, but I haven't written here on the board, hadn't written it, the mediation. I mentioned there's a bunch of temporary orders, hearings. Now you've got this, you've got stays that you're involved in. You've got clarifications that you're asking the judge to write here. You've got, before you do your appeal, you're going to ask them for rules of law. right? You're going to ask them to justify their decisions, and I know I'm not giving you all the full technical terms here because you're going to get that in class, and I want to keep this as short as possible. It's already gone long. But anyway, so you're going to ask for a lot of things from the judge in this section to clarify the situation and develop the record all the way through so that when you go to appeal, they see that you gave that judge every opportunity to do the right thing. Okay. So after that section, look at my notes here. You are going to want to know, remember we mentioned this at the beginning, what the rules for appeal are, the deadlines and the rules. Why is that? Because if you don't know what they are, you're not making sure you produce them throughout this process. So if the appellate rule says that you have to preserve your argument by objecting to it and getting a ruling on that objection, or by filing or presenting it and making sure it's clearly on the record, and you didn't know that, you might not have been doing that. There are tons of attorneys that do not develop the record, or maybe you wouldn't have gotten a court reporter on all of these, or maybe you would have spoken off the record. So by knowing these rules, that's the reason a lot of people do it this way, is because they know that if the court does the wrong thing, or if they're trying to establish rules of law for their argument, clear rules of law for it, they need to do this. Okay. So the other thing is you have to know how many days you have before you have to file that you intend to appeal. And here's something people get confused on a lot of times is they think that as soon as they file the appeal, their brief is due in 30 days. It's not. But your intent, your motion informing the court that you're going to file that appeal might be due in 30 days. In some states, it's due in 10 in some situations too, right? And also there's some parts of the process where you, and we didn't go over this because it's not appropriate for here, I'm going to mention it. You might have had an administrative judge, a judge, and that's a judge that your judge in your court refers to another judge that they've hired in their court to help relieve them of some of that load because their load's too heavy for just the main elected judge. So they actually hire judges called administrative judges. Your state may call them different things, but basically the same thing. It's a judge that sits in for your judge to handle some of the caseload, not one that's sitting in if your judge is out sick necessarily, right? They could be doing that too, but they do have other judges for that as well. But the point is, the reason I brought that up is because an appeal process is different initially. To challenge their orders is a different process. You have to ask for first the main judge of the court to review that order. Okay. And again, I don't want to go into too many details. I don't want you guys to get hung up on that. We'll talk about that in another video, but the process is longer. I usually recommend to people don't go through administrative judges if you can help it, because it increases your expense. Because if you have to go through a trial with that administrative judge and then go through a trial again with the main judge, you've doubled your expense there, right? And we didn't even go over jury trials. Some states allow jury trials for certain things. So you can see how the expense can build very quickly to $70,000 or above. So with our motions, when you're making these arguments, we tell you don't ask for a gal. It's going to cut out $35,000. If you already have one, you might save, because you're shutting down so many of the things that they do, right? You're objecting to them evaluating anything that has to do with your beliefs, your values, and your decisions regarding your child. So there's not a whole lot there for them to do. So you're shutting down their justification for their expense. You would be arguing that they don't get to decide best interest of the child because you're a fit parent. You make that determination, that decision. A lot of people quote that out of Troxel. If you've taken our courses or you've been in our membership site, then you'll see that it actually comes out of another case. So if you know it, post it in the comment down below, and I will give you access to the audiobook of our green book. If you can post what case that comes out of, but I'm only going to do it with the first person. The first person that posts that down below this video will get free access to our audiobook of Not in the Child's Best Interest. Okay. So let me see what else I want to cover here. We've got 3, now 4. Section 4, appeal. So you've done all of this, you've decided you're going to go on to appeal. And you're not going to go on to that if you didn't litigate your federal issues all the way through, are you? And we're not really going to go over like all the different things in appeal because this is getting too long. But I want to go over what are a couple of examples of procedural due process violations. Because I want you guys thinking about, do you want to do parental rights? Some other ones are, let's say if they suspend all your contact with your child without any clear and convincing evidence and they claim that they can use preponderance, right? You have to know how to argue these are fundamental rights that are involved in this case. We've addressed that for you in our motions package. Okay, it's super, super important. A lot of people are attempting to get that passed with legislators. So, but let me tell you, even when they get certain things passed with legislation, I haven't seen any of the bills yet address all of this. So you're still going to have things that you're going to end up fighting over, possibly because they're just not understanding what it means to protect the fundamental rights. So even with clear and convincing evidence, I've heard some people say that means they need to get an expert, and the expert has to say what it is that the other parent did in order to, before they violate your rights. And that's not the case. You don't need to bring experts in. It doesn't raise the cost of your litigation. It just means that there has to be more evidence than just you stating that something happened, right? Or not happened, but more evidence go towards why you can get the relief you're asking for. If you're wanting more time than equal, like you want the other parent to have less than equal time, you'll need more than just a difference in opinions, right? Oh, and you'll need more than just, I feed my child at 5 o'clock at night, but she doesn't feed the child until 10 o'clock, or she has so many jobs that she doesn't get to spend as many waking hours. Those are all personal decisions. So you need more than that, but it doesn't require an expert to come in and say why your equal rights should be protected. You don't need that. So my head's a little fuzzy, so I'm not thinking super straight. But if you have questions and you want me to address those regarding the content, you have an example that you want me to address, I do a lot better on those down there because my head is thinking these technical things right now. Okay, so what else would be a procedural due process violation? Let's say you get denied access to the courts. That's a big one. A lot of people are being told that they cannot file in the courts unless somebody approves the filing, right? So that may be one that you want to argue. Also, they get told that they can't file because they're harassing the court. Okay, so again, that may be one that you want to argue because they try to say that arguing your rights is harassing the court. So you have to really look at it and make sure you're not actually harassing just because you're pissed off, because that's what they'll try to say that's what you're doing. So make it very clear that even if you're repeating an argument, that you're doing it at the appropriate time and appropriately and in response to the relief that the other side is asking for. So if that other side is continually throughout the process asking to violate your equal time with your child, then of course you're going to keep bringing up the right that they're violating. So just make it clear that that's why you're doing it. Okay. And if they're going to keep saying that it's vexatious litigant or claiming, look up that statute, make sure they've actually satisfied all the prongs of that statute. And if they have, and that statute is advocating to violate your rights, then you're going to want to challenge that statute, aren't you? So that's some of the analysis you do to decide some of the strategies and what and when you need to do something. But our motions package also helps you with that, what and when and where to use the arguments. And our class is going to walk you through these things in more details than what we're doing now. So I'll actually break some classes down and say, we're just going to handle mandamus in this class, or a piece of it, or we're just going to handle the guardian ad litem in this class, right? Okay, so what else on appeal? Let me check my notes. Last stage is the federal constitutional arguments that we were talking about. We've talked about through the whole thing. So overall, what's happened, right? When you use these motions, you're not having to pay hours and hours and hours for your attorney. So let's say your attorney's $300 an hour, and let's say they're going to say they usually don't give you just a book price on it, but let's say they need another $10,000 to make those arguments. And I guarantee you, they won't be the arguments that Ron's refined them down to. That took over 1,000 hours of working on case law, and then it had to process through his brain. Everybody's got a unique brain, just like you've got a unique fingerprint. So there's no way somebody can craft what he did. But that little orange book that I told you about, for everybody that watches these videos all the way through and can tell me something that I said near the end of this, and then sends me their email, I will email you a link so you can read that orange book, okay? So just tell me you want to read the orange book. So if they ask you for 10,000, you cross that out and you go to our motions package. I'm not going to quote price on here simply because I can tell you it's well under $1,000. If you're buying the class and the motions package, then you might get closer to that, but we run deals on it all the time. So you want to make sure you get that special. So keep a lookout for any videos we put up here or on our website, because we want to make sure you can afford to do this, because we certainly cannot afford to keep doing things this way and hurting our children and hurting our economy and hurting all of the families in society. Because that's what's happening when you start cutting children out of parents' lives who are fit, but perhaps just making decisions that that particular judge or the other parent doesn't side with, doesn't agree with, doesn't like. Not being liked is not your bar to having your parental rights, your constitutional rights protected by court of law. So thanks for coming out with me tonight. I appreciate it. Let me know if you have any questions. I'm Sherry Palmer with www.fixedfamilycourts.com. See you next time.